Hello and a very warm welcome to the Analyst dated 29 July 2025, brought to you by Vajiram and Ravi, wherein we'll be covering the 7 set of current affairs issues which have featured in today's newspaper. The handout of this very discussion is available in the description below for your future reference. Beginning with the analysis section, firstly we'll try and understand that why when it comes to India, there's a long wait for justice, why Indian courts are clogged, what are its impact, and what steps need to be taken in this particular backdrop. Moving on to the second topic, as the national education policy has completed 5 years, so in this backdrop, we will be gauging its progress and the challenges which are still there with respect to its implementation. Moving on to the simplified section, herein we will be covering the 5 set of current affairs issues in the most simple manner possible, and we will also be doing the value addition which would be relevant for your prelims examination. So stay tuned. Let's begin with the first topic, which is dealing with the backlog of cases in Indian courts. This particular topic we can associate with GS paper 2, functioning of Indian judiciary. What is the context? So a data point has appeared in The Hindu, which is giving us the numbers of the cases which are pending at different courts in India. And due to this judicial backlog, the Indian citizens have to wait longer and longer for justice. Now, before we understand the reasons for judicial backlog, let's just first look into the data point. So if you go by the National Judicial Data Grid, over 86,000 cases are pending when it comes to the Supreme Court, 63 lakh cases are pending when it comes to High Court, and 4.6 crore cases are pending when it comes to the district and subordinate courts. And one another interesting element that has been given in this today's data point is criminal matters are being resolved at a faster pace as compared to the civil ones. Criminal cases basically are considered to be as a crime against the state. For example, the cases which are dealing with rape, murder, etc. When you talk about the civil matter, it is basically dealing with property related dispute, commercial disputes, family related disputes, etc. As you can see, more number of criminal cases have been resolved when it comes to High Court. So less criminal cases are pending when it comes to High Court as compared to the civil matters. But the problem is at the district as well as the subordinate court level. Why? Because here the disposal of civil matter is done at a quite slow pace. As you can see, 38% roughly, civil cases were resolved within 1 year, and 20% of the civil matters were resolved within 5 years. Okay, so this is the statistics which you can use to write the introduction to a particular question which is dealing with judicial backlog. Now let's explore the reasons for the same. First and foremost reason for this is shortage of judges. So today's data point tells us that out of this many sanctioned posts, more than 5,000 posts are vacant when you talk about different courts in India, and majority of the posts are vacant when it comes to the High Court and then the district courts. Another interesting element which the data points is highlighting that even if we fill all these posts, okay, more than 5,000 posts which are vacant, then also we will be having merely 19 judges per 10 lakh population, which is quite less as compared to what the Law Commission has suggested in its report of 1987, that we need to have 50 judges per 10 lakh population. So this is one of the pertinent cause of judicial backlogs in India. Then another reason is less working days when it comes to the Supreme Court. So on an average, in a year, Supreme Court works for 188 days. But the Melimeth Committee has recommended that it should work for 206 days. Only then we will be able to effectively dispose the cases which are pending at the Supreme Court. Then another reason is adjournment culture. You must be aware of the famous dialogue Tariq pe Tariq. Why the lawyers are able to get different dates for the same case? Because there is no clear timelines when it comes to filing of the case, witness examination and hearing. Then more frivolous cases are being filed at the Supreme Court. Recently, Supreme Court imposed 5 lakh fine on a petitioner which has filed a PIL, wherein the petitioner was challenging the conclusions of Charles Darwin evolution theory and Albert Einstein conclusions, wherein the court pointed out that the petitioner needs to re-educate himself. Then majority of the cases which are pending before the court, in 50% of the cases, one party is the government. So this is another cause. Then there is delay in evidence collection. So there are issues with the criminal justice system as well. Our police force lack the forensic labs, and this was something that came across in Arushi Talwar case as well. The police took 9 years, more than 9 years, to gather the evidence against the suspected culprits. But ultimately what happened? Because of lack of conclusive evidence, these suspects were acquitted by the High Court. So these are the prominent reason of judicial backlogs when it comes to India. Now, having understood the reason, let's understand the impacts of the same. So first and foremost, it erodes the constitutional rights. In Hossainara Khatoon case, Supreme Court has recognized right to speedy justice as an implicit right under Article 21. But what is happening because of pendency of cases? Justice is getting delayed and ultimately being denied. And this is also going against Article 39A, which talks about securing equitable access to justice for all. Then it is leading to black coat syndrome. This term was given by the President Draupadi Murmu. Why? What is happening? Because of justice getting delayed, people don't have the incentive to go and file the cases in the court. So ultimately it is reducing the trust of the citizens when it comes to the Indian judiciary. And when the citizens lose the faith in the justice mechanism, what happens? We witness instances of mob lynching because people start taking law in their own hands. They want to do justice on their own because they don't, have faith in the judicial mechanism. Then it would be increasing the burden on the judges as well. So when you have huge pendency of cases, the judge is not able to give due time to a particular case, wherein maybe an important constitutional question would be involved. And if you go by the data given by the Department of Justice as of May 2022, we have roughly more than 25,000 judges to hear over 4.7 crore pending cases. So you can understand that how it would be having a negative impact when it comes to the quality of the judgments, because the judges would not be able to give due time to a particular case. Then it is leading to overcrowding of the prisons as well. So if you go by the prison statistics of 2020, which is actually released by National Crime Record Bureau, 76% of the total inmates in prisons which are there across the country, they are under trials. Under trials are basically those people against whom the case is going on in the courts. The court has not given its final verdict. And majority of them are from economically weaker sections. Then it is also having a negative economic impact as well. If you go by the report given by Bangalore-based Daksh organization, the judicial backlog cost around 1.5% to 2% of the GDP. Why? Because when there is delay in justice, the investors would be losing confidence in your judicial mechanism. And actually it adds to cost overrun. What is cost overrun? Let's suppose in a particular year, I saw that within 10 crore, I can execute this particular business plan. But matter went to the court because of some land acquisition related issue maybe. And it took 5 years for the court to give its verdict. Now within 5 years, the cost needs to be adjusted. Now I might be able to complete this project in 20 crore. So if I have to invest more amount of money to carry out the same project, don't you think so the foreign investors would not be incentivized to come and invest in the Indian economy? And that is how the pendency of cases in the courts in India is negatively impacting the Indian economy. And lastly, because of this, we witness judicial evasion as well. What is judicial evasion? So by citing the pendency of cases at different courts, the judges are rescuing themselves. They don't want to hear constitutional matters. For example, when it comes to the matter which was questioning the electoral bonds, the case was filed in 2018, but the verdict came in 2024. Similar was the scenario when the case went to the Supreme Court with respect to Aadhaar Act. Court took roughly 5 years to give its verdict. So because of pendency of cases, the judges, by citing this as a reason, they are not giving due time to important constitutional matters. Now, what all steps we have taken to address this particular issue? So we have e-courts project, wherein we are enabling e-filing of the cases. We are doing video, hearing of the cases. We have the National Judicial Data Grid, which gives us the real-time picture of how many cases are pending at what level of the courts. Then we have created fast-track courts also. For example, we have fast-track courts to look into the POSCO-related matters, which ultimately reduces the burden on the traditional courts. Then we have National Litigation Policy of 2010, which would make sure that in majority of the cases which are pending before the court, Government of India is not a party. And how the government would be doing that? By doing pre-litigation assessment of the case. And in this particular policy, they have also one provision that penalties would be imposed on that particular department, which is, filing frivolous appeals as well. Then we are encouraging alternative dispute resolution mechanism. For example, we have national lok adalats, and this data point was given in today's newspaper itself, that how this alternative dispute resolution mechanism in form of lok adalats, we have been able to resolve roughly 27.5 crore cases. 22 crore cases which were at the pre-litigation stage, that means the case was not, admitted by the court, and roughly 5.3 crore cases which were pending before the courts. Why these alternative dispute resolution mechanism are effective? Because they are guided by principle of natural justice, and they have the flexibility when it comes to hearing the cases, and they are able to provide speedy justice in a timely manner. Then we have also seen Supreme Court imposing fines for filing of frivolous PILs as well. Now, what more needs to be done to effectively address this issue of judicial backlog? First and foremost, we need to do timely appointment of the judges, and we need to make sure that we have roughly 50 judges per 10 lakh population, what the Law Commission has suggested. In order to address the backlog at the High Court level, the Supreme Court has suggested that we can appoint the retired judges as ad hoc appointees in the High Court. Then another suggestion which the 10th Law Commission has given, that in order to prevent or to avoid this judicial evasion, what we need to do? We need to create two divisions of the Supreme Court. One would be the legal division, which would be looking into, ordinary matters. One would be the constitutional division, which would be adjudicating important constitutional cases. Then we need to increase the number of work days also, as the Melimeth Committee has suggested that the Supreme Court should work for 206 days in a year, and we need to reduce the number of holidays as well. Then we need to encourage the alternative dispute resolution mechanism. Especially we can do this thing for the civil related matters and commercial related disputes, that they need to mandatorily explore the alternative dispute resolution mechanisms which are there. For example, mediation, arbitration, etc. And once they have exploited this particular mechanism, only then they should be allowed to file the case in the traditional courts. Then, in order to address the issue of quality of judges at the subordinate and the district level courts, we can come up with the All India Judicial Services. And this would also address the vacancy crisis when it comes to district and subordinate level courts. Now, when it comes to creation of All India Judicial Service, under Article 312, Rajya Sabha is having the power that it can pass a resolution in this respect. Passed by what kind of majority? You need to let me know in the comment section. And once the Rajya Sabha passes the resolution in this respect, then the Parliament can introduce a law in this respect for creation of All India Judicial Services. All these steps would go a long way in ensuring that justice is delivered in a timely manner, and the Indian citizens don't have to wait longer and longer to attain justice. With this, we have come to end of this particular topic. I have framed a practice question for you people. So based on what we have discussed, try and attempt this particular question. With this, let's move on to the next topic. Now, the next topic is dealing with the National Education Policy, as this policy has completed 5 years. This particular topic we can associate with GS Paper 2, issues related to education. Now, when I talk about this particular policy was drafted by a committee which was headed by Dr. K. Kasturi Ranjan, and this committee was created by Ministry of Human Resource and Development way back in June 2017. Now, this particular policy replaced the previous national policy on education, which we came up in 1986. And this National Education Policy 2020 is the third such policy since independence. Now, when it comes to this particular policy, the primary emphasis of this particular policy is to develop creative potential of each individual. Let's understand how we are going to do this. So, under this particular policy, we have shifted from the rigid and compartmentalization approach. Okay. Now, under this particular policy, the students would be allowed to read arts, humanities, science subjects at one go. And they can actually explore that where their passion actually lies. Then we are also providing them vocational education, which would be starting from class 6 onwards. So internships would be provided to them. And we are also focusing upon language proficiency. So recognizing the linguistic diversity that we have. Under this particular policy, the medium of instruction till grade 5 should be in mother tongue or in regional languages also. Then under this particular policy, we are planning to improve the gross enrollment ratio when it comes to preschool to secondary level education to 100% by 2030. And this policy also states that we need to increase the gross enrollment ratio when it comes to higher education to 50% by 2035. For this, we need to create more number of seats when it comes to higher educational institution. This policy also focuses upon, improved method of assessment for the students. We'll be discussing it in the subsequent slide. And it also talks about improving the teacher training as well. Okay. Teacher should come up with learner-centric pedagogical approach. Now, when it comes to this particular policy, what all things have worked? Okay, what all areas we have been able to make ample progress? So first and foremost, improving or changing the school curriculum. So from 10+2 system, we have actually moved on to this new structure wherein we are focusing upon the foundational learning so that we create a strong foundation. Then only the students would be able to grasp the higher, not higher actually, whatever education they are getting in class 3 and 5th grade. Then middle and then secondary 9 to 12th. So in order to highlight the outcomes of all these different stages that we have created under this national education policy, we have the National Curriculum Framework for School Education. And under this framework, the NCERT has come up with new textbook for class 1 to 8, wherein we will not be seeing different textbook for political science, history, economics, geography. We will be having only one social science textbook. And new books would be released by the NCERT for 9th and 12th class also. This is in pipeline now. Then we are universalizing the pre-primary learning so that the child has the requisite foundation. Okay, from there on it can build upon. And in this respect, we are already using NCERT's Jadui Pitara learning kits, which is making education a fun learning activity for the students who are at the pre-primary level. And in this respect, the Ministry of Women and Child Development has issued a national earlier child care and education curriculum. So we have universalized the pre-primary learning thing. Then we are focusing upon foundational skills. So under the Nipun Bharat, which was launched in 2021, what is our focus? We are focusing that a child at the end of class 3rd is able to read basic English text and is able to solve the basic maths related questions. And based on the recent government survey, we found that 64% of the children which are at the end of class 3rd are able to read the basic English language text and 60% of them are able to solve the basic maths related questions as well. So this is a great improvement. Now under this particular framework, we have come up with credit based flexibility. What do we mean by this? Now let's take an example. Let's suppose I enrolled in a BA course which is of 3 years, 3-year degree course. After 1 year, after I completed my first year of graduation, I got married, so I could not continue my education. Now, after 2 years of my marriage, if I again want to continue my graduation, I need to start from the first year. But this has been changed through the academic bank of credit. What we are doing under this? Let's suppose if I have completed the first year, I would be provided with the certificate. If I completed second year, I would be provided with a diploma. And let's suppose because of any reason, I could not continue my study, let's suppose after first year or second year. And after 2 years, again, if I want to start my study, I don't have to start from the very first year of graduation. I would be starting from wherever I left. Okay, that is what is academic bank of credits. And we are also developing this credit framework for school students as well. We are providing them the flexibility, how many hours they are putting into learning, what all vocational training they have attained. Based on that, we will be giving them the credit. Although when it comes to school students, this is in pilot mode right now. Then under this particular policy, we have also come up with a common entrance test when it comes to the universities. Previously, what used to happen? There were multiple entrance tests for different universities. So we have to prepare for all the different multiple entrance tests. And at times, the dates were also clashing. So to avoid that, we came up with a common university entrance test which was introduced in 2022. And under this particular policy, we are also enabling the Indian educational institution to open their branches abroad. Like for example, IIT Madras, IIT Delhi, IIM Ahmedabad, they have set up their international campuses in Abu Dhabi, Dubai, etc. And we have also seen establishment of the foreign universities in the Gujarat gift city as well. Now, having understood the areas where we have made considerable progress, let's just look into the areas where we are still making progress. Okay, that means in all the regions we are not seeing this particular progress. Only in certain regions we have made the progress. First and foremost, changes in the board examination. Now, previously what used to happen? You were supposed to give one board exam in 1 year. So this used to add stress and anxiety level when it comes to the students when we were in our 10th and 12th class boards. But now, to relieve the students from this exam stress, what changes we have brought? Now the students can give the exam twice. But you need to understand this thing, that when it comes to class 10 student, when the first phase of examination would happen, whosoever would be passing the first phase of examination, they would be given with another chance that they can improve their scores for 3 subjects, not for all the subjects, for 3 subjects. Okay, and in whatever phase you got the highest marks, that marks would be taken into account. Okay, but this thing is being implemented in Karnataka, but in other states, we have not made considerable progress. Then we plan to came up with the holistic report cards. We have planned that under this particular policy, we would not be focusing upon rote memorization. So basically, we will not be focusing upon marks. Rather, we will be focusing upon competency-based assessment, wherein continuous internal, test would be there, different problem-solving activities would be there. So in order to come up with the holistic report card, we have Parak, which is a unit which has been created under NCERT. Okay, but considerable progress has to be done in this particular regard. Different schools have not just, adopted this holistic way of analyzing a student's performance. Then there is slow progress when it comes to 4-year UG degree. Kerala has implemented this thing, but this needs to be seen in other universities in different states. They have, the colleges have stated that we don't have the requisite facility and the infrastructure as well as the faculty to go with this 4-year UG degree program. Then when it comes to using mother tongue or the regional language as the medium of instruction. Now in this respect, we are facing logistic challenges. Logistic challenges, why? Because we need textbook in different Indian languages. We also need teachers who can use the regional languages as a medium of instruction. So this is the challenge that we are facing when it comes to using mother tongue as a medium of instruction, because the NCERT is still working so that it can come up with textbook in different Indian languages. Now, having understood the areas where we have made the progress, let's just understand what all areas we are facing challenges. So first and the foremost challenges with respect to 3-language formula. Under this 3-language formula, what the national education policy has to say, that the 3 languages should be used, 2 needs to be Indian languages and 1 language could be a foreign language. But this thing is being seen by Tamil Nadu as an attempt to impose Hindi language. Now, another issue that we are facing is with respect to teacher training. So, the National Curriculum Framework for Teacher Education is still due in 2021. It is yet to be released, wherein we have planned a 4-year integrated B.Ed course, which the different colleges which are providing the B.Ed course, they are opposing. Then the successor of UGC, that is Higher Education Commission of India, a bill to introduce this particular body is still pending. This particular body, under this particular policy, we have intended that this would be the body which would be regulating the higher educational institution, the funding of these higher educational institution, the accreditation of higher educational institution, etc. Except the higher educational institution which are in the medical and the law domain. Okay. But a bill in this respect is still not been introduced. Then The Education Ministry has given a proposal that we should provide breakfast as well as midday meal to pre-primary and students who are studying at pre-primary and elementary classes. But this was denied by the Finance Ministry, maybe because of the financial constraint. Then there is tussle going on between different states like Kerala, Tamil Nadu, West Bengal with regard to implementation of PM Shri schools. Why? Because center is putting a pressure on these states that you sign a MOU with us for implementation of PM Shri schools. But why these states like Tamil Nadu, Kerala, West Bengal, they are denying signing this MOUs? Because under this MOU, they are being forced to implement all the provisions of National Education Policy. And as we discussed, Tamil Nadu is having the issue with 3-language formula. So that is the reason we are seeing the tussle with respect to PM Shri schools also. What we are planning to do under this PM Shri schools? Will we be creating new schools? No. The existing schools only would be upgraded. We will be improving the infrastructure there. Okay. We will put in the model laboratories, etc. And we would be doing the assessment in a different manner, promoting critical thinking, analysis, etc. And we would provide this education to the students that they should learn about water conservation, etc. But since these states, they have not signed the MOU with the center government with respect to setting up of the PM Shri school, the center government has actually withheld the funds for Samagra Shiksha Abhiyan as well, and the matter has went to the court as well. Now, these were the issues which the article has pointed out. What all further issues we are witnessing? First and foremost, fragmented learning because of this credit-based mobility. Now, see, education is all about understanding the concept and applying that when it comes to solving real-life issues. But if I am having a 2-year gap, let's suppose, in my education, don't you think so I might have forgotten all the previous concepts that I read? So ultimately, because of this credit system, what is happening? You are making education merely a means of living in this marketplace. We are not focusing upon holistic development of a particular individual. Then we have reduced the syllabus. Why? Because we wanted to adopt a multidisciplinary approach. And as we discussed that NCERT has actually come up with one social science textbook. We will not be having separate geography, history, political science, economics textbook. Don't you think so this would be affecting the core knowledge of the students? So we are reducing the syllabus in order to implement this multidisciplinary approach. For example, the literary work of Walt Whitman's Passage to India. Okay. This thing was in huge number of pages, but now in less number of pages the same poem is being taught. This is problematic. Then because we are focusing on multidisciplinary approach, we are diluting the core subjects, and this is what is happening in the St. Xavier's University of Calcutta, wherein only 1 out of the 8 papers directly focuses upon the honor subject, that is economics. So don't you think so? Because of focusing upon multidisciplinary approach, we would be losing domain expertise. And at the end of the day, we need domain expertise as well in order to solve the real life problems. So this is again problematic. Then, although we have done away with one exam in the entire year, but under this national education policy, there are a lot of internal assignments, continuously different papers are there. So that is putting excessive assessment load on the students. And in the national education policy, we have also planned that we will be coming up with the e-learning kits. But we need to understand the harsh reality when it comes to Indian society is we have digital divide when it comes to rural and urban areas. According to Oxfam report, merely more than 30% of the people in rural areas know how to use the internet. However, the number in urban areas is more than 60%. So we need to address this digital divide because it is impacting sustainable development goal 4, especially when it comes to the students who are there in the rural areas. So in this backdrop, what needs to be done? The center needs to, build a political consensus with the states like Tamil Nadu, Kerala, West Bengal, because coercion policy would not be working. And ultimately, when it comes to education, it falls under the concurrent list. So the different, commissions also, which were formed to look into the center-state relation. Sarkaria Commission, Punchi Commission, they have also recommended that when it comes to a subject which is there in the concurrent list, the center and the state government should make use of different platforms which are there to build political consensus on those particular subjects. So that needs to be enforced. Then we need to address the logistic challenges. As I told you, we are focusing upon the language proficiency, that okay, education should be provided in the mother tongue or the regional language. But do you have the requisite teachers? Do you have the textbook ready in different Indian languages? So this needs to be addressed. Then the successor of UGC, with respect to that, the bill needs to be enacted so that we can improve the overall regulatory landscape when it comes to higher educational institutions. Then, in order to solve real life problems, we understand that okay, we need a multidimensional approach, and that is the reason we are focusing upon multidisciplinary approach under this national education policy. But at the same time, you also need to understand that we need experts which are having their domain knowledge. So we need to strike a balance when it comes to developing domain expertise as well as multidisciplinary approach. And lastly, in order to effectively realize the Sustainable Development Goal 4, especially when it comes to rural areas, we need to improve the digital infrastructure there by ensuring effective implementation of BharatNet project. Okay, that's all that we need to know with regard to this particular topic. I have framed a practice question for you people. So based on whatever we have discussed, try and attempt this particular question. With this, let's move on to the simplified section. So, beginning with the simplified section, an editorial has appeared in Indian Express which is dealing with the advisory opinion given by the International Court of Justice with respect to climate change. This particular topic you can associate with GS paper 3. Now, in the recent advisory opinion, International Court of Justice, in an unanimous way, it has declared that climate change is an existential threat. And this case was actually initiated by Vanuatu, which is a Pacific island nation. It led a coalition of small island states. It got the approval from United Nations General Assembly to ask the International Court of Justice two questions. What are states legally required to do to address the climate change, and what will be the consequences if they do not fulfill these particular duties? Now, before we look further into this particular article, let's just note down certain prelim facts with regard to this particular island nation. So, it is an archipelago which is part of Melanesia, and it is an island situated in the southern Pacific Ocean. It is situated east of northern Australia, as you can see, and west of Fiji. Its capital city is Port Vila, and as it is located in the Pacific Ring of Fire, this region is prone to earthquake, tsunami as well as volcanic eruptions. Previously, this region was controlled by Britain and France together. It got independence in 1980. Now, the article is pointing out what all steps India has taken. Now, previously we have discussed that we had already made sure that more than 50% of the installed electricity capacity is comprising of renewable energy. Then we are close to meet our emission intensity target, wherein we have stated that we will be reducing it by 45% as compared to what we used to do in 2005. And we are also close to attaining the afforestation goal. Okay, as you can see, based on this particular report of India State of Forest, recent report which is there, we will be easily meeting the target of creating additional 3 billion tons of carbon equivalent carbon sink. And then the writer further points out that we were the one who led the International Solar Alliance. We came up with the Mission Life campaign, which basically talks about what all efforts you can do at an individual level, okay, which talks about promoting sustainable consumption. And during the G20 presidency also, we highlighted the issue of climate finance as well. Now, the writer further points out that because of this advisory opinion of International Court of Justice, India would be witnessing three major challenges. First challenge is with respect to legal domain. Already the Indian courts have declared right to a healthy environment as a part of right to life under Article 21. For example, you take the Ranjit Singh versus Union of India case of 2024, wherein the Supreme Court has stated that it is a fundamental right to be protected from the adverse effect of climate change. Now, in this backdrop, combining with the advisory opinion of International Court of Justice, the writer is pointing out that we might be witnessing a huge increase in the litigation, wherein the the litigant might be demanding stronger action against climate change or higher compensation. So the writer is pointing out that we need to anticipate this particular legal scenario and we need to prepare ourselves for the same. Second challenge would be on the enforcement front. Already when it comes to India, our environmental laws are strong, but the implementation is patchy. If you talk about the pollution control agencies, they are underfunded, there is vacancy crisis also, and compliance actually varies from state to state and sector to sector. So we need to strengthen our regulatory capacity. This should become a national priority. Third challenge would be with respect to subsidies given by the government for fossil fuels. Now, the subsidy given by the government for fossil fuels like cooking gas, kerosene, this subsidy is crucial for economically vulnerable households. But when the government is doing so, it is actually delaying the shift to cleaner alternatives. So we need to make sure that how we can provide support to the poor section without locking them into polluting fuels. So we have to come up with an innovative mechanism for the same. Now, lastly, the writer is pointing out that what would be ultimately the effect of this particular advisory opinion given by International Court of Justice. So this would incentivize the countries to cooperate when it comes to climate change related issues, and they would be incentivized to adopt ambitious national plans. And this advisory opinion of ICJ has affirmed the principle of common but differentiated responsibility, which India has always vouched for. So this ICJ has now given that argument a legal grounding. Ultimately, this would be incentivizing the country that they come up with better climate goals, they chart a harder but fairer course, and we will be looking at how India would be addressing the challenges which this advisory opinion of ICJ would be creating. Okay, how it aligns the duty with dignity and ambition with justice. That's all that we need to know with regard to this particular topic. Let's move on to the next one. Now, a very interesting fact came in today's Indian Express newspaper that Nigeria, which was on 50th rank across the world, within single day, it became the 55th largest economy in the world. This particular topic we can associate with economy section of prelims. So this West African country, which was on 20th July at the 50th position, in one day it became the 55th largest economy in the world. How come? It is because of the changing of the base year of its GDP. Previously the base year was 2010, now it has changed to 2019, and this is the reason the GDP in nominal terms have increased. Previously it was $187 billion, now it is $243 billion. Now we need to understand that what is a base year. So base year prices are used to calculate the real GDP. In real GDP, we will be using the price of the base year, multiplying it with the total output produced in the current year, and this would be giving us the real GDP. So apart from changing the base year, there are other changes also which this country has done. It has included various undocumented, uncounted sectors which were not taken into account to calculate the GDP previously, such as digital services, pension fund operation, e-commerce activities, etc. And the data which is used to estimate the GDP, that has also changed, okay, so that it could reflect the current economic realities. Now, however, this is not the first time that this country has changed its base year for its GDP estimation. Previously also, it has changed it from 1990 to 2010, and at that time, its GDP nominal term in 2014 was roughly $510 billion. Now, isn't it confusing? Now it is $243 billion. 2014, it was more than $500 billion. So this points out certain concerns which are there with respect to this particular country. Now, this drop in the nominal GDP when it comes to Nigeria points out some concerns. What are those concerns? What we have found out when it comes to its GDP estimation currently, the share of agriculture when it comes to Nigerian GDP, that has gone up. Industry share has gone down, and the contribution of informal sector has gone up. And why in nominal terms the GDP of Nigeria has declined as compared to what it was in 2014? It is because of the sharp devaluation done by the Nigerian government in 2023-24. What is devaluation? Wherein the government deliberately reduces the value of its domestic currency vis-a-vis the foreign currency. And one more concern has been pointed out. Although the debt to GDP ratio has gone down from 51% to 38%, but this does not addresses the issues that the government is witnessing when it comes to revenue generation. Okay. Now, all these things are not very much important. What is important for us is the changing of base year, which India is also planning to do. Okay. So, the Ministry of MOSPI has constituted a committee under the chairmanship of Bishwanath Goldar to change the base year of the GDP from 2011-12 to 2022-23, and the numbers would be released by February 2026. The last time we changed our base year was in 2015, and based on the current GDP data that we have, according to IMF, India is currently 5th largest economy in the world, and it is right behind Japan. So as I told you, the last time we changed the base year was in 2015, and when we will be changing the base year now, this would be the 8th time that we will be changing the base year when it comes to GDP estimation. And Advisory Committee on National Accounts Statistics will be reviewing the data sources also that we will be using to effectively account for the GDP. Now, why there is a need to change the base year on a regular basis? To effectively capture the changes in the economic structure. Previously, agriculture used to, contribute more to our GDP, but that is not the scenario today. Today, services sector is contributing more. E-commerce, etc. These are the new sectors which have emerged. So, we previously don't used to take into account these particular sectors. So, in order to take into account these sectors, we need to change the base year. Okay, then only we will be able to take into account the other data sets as well. And this would give us an accurate understanding of our real GDP also. What did I told you? How do we calculate real GDP? Price of the base year multiplied by output in the current year. Now imagine in 2015, the price would be quite less, but the price have increased many-fold by this particular time if you compare 2022-23 as the base year. So when we will be using this as the base year, then we will be getting an accurate picture with respect to the real GDP as well. Because inflation scenario has changed over a period of time, and that needs to be accounted in the GDP estimation. Then when we change the base year, then we will be able to look into the data sources also, how we can improve the methodology, how we can use different data sources to cover the different sectors which have emerged right now, biotechnology, e-commerce, etc. And this would enable us to effectively reflect the new economic activities. And when we update our GDP, obviously, as we have witnessed with respect to Nigeria, our GDP would also witness an increment in nominal terms, and this would enable us to do the comparison of the GDP when it comes to other countries, because other countries on a regular basis they keep on changing their base year. Why? So that they can effectively take into account the changes in the price or the inflation scenario as well. That's all that we need to know with regard to this particular topic. Let's move on to the next one. Now, recently, Thailand and Cambodia, they have agreed to enter into a ceasefire because of the pressure from US President Donald Trump. This particular topic you can associate with prelims. Now, you can get a mapping related question. So, let's look into what all are the bordering countries when it comes to Cambodia. So, it is Thailand, Laos, Vietnam. And when you talk about Thailand, so it is bordered by Myanmar, Malaysia, Laos and Cambodia. So, what is the matter? The two countries have entered into a ceasefire. The conflict emerged. Why? Because a landmine exploded near the border of the two countries. And then we witnessed tit for tat action from the two countries, banning the imports, expelling the envoys, calling back their ambassadors. Then there was exchange of artillery also between the two countries. What is the bone of contention? Why there's a conflict between these two countries? First reason is the border which was drawn by the France in 1907. So because of this, there is a land, dispute between the two countries. And another dispute is with respect to who is the original owner of the Theravada Buddhism. Both countries claim that they are the original owner of this particular heritage. Another bone of contention between the two countries is with respect to this temple, Priya Vihar temple, okay, which is situated here. Now, this temple is a place of worship for the people belonging to Thailand as well as Cambodia. This temple was built in 11th and 12th century during the Khmer Empire, which at that time ruled the Thailand region as well. But in 15th century, this empire became weak and the Thailand Siam region was, chipped away from Cambodia territory. Then in 1867, Cambodia officially handed this area of Priya Vihar to Thailand. But when the France entered, it drew the border between the two countries and ultimately this temple fell under Cambodia. But then what happened? In 1941, Thailand actually entered into an alliance with Japan and it seized this particular temple. Ultimately, at the end of World War II, it has to give this temple back to France. Then in 1954, after Cambodia's independence, the Thailand, military troops once again occupied this particular temple. So in this backdrop, Cambodia went to International Court of Justice and this International Court of Justice upheld the Cambodia's claim over this particular temple. But the tensions again emerged in 2008 when Cambodia sought to list this particular temple as a UNESCO World Heritage Site. So Thailand, criticized this particular thing that this act is going against their sovereignty. Although in 2013, the International Court of Justice reaffirmed Cambodia's position vis-a-vis this particular temple and it talked about creating a demilitarized zone around this particular temple. But this demilitarized zone never came into picture. That's all that we need to know with regard to this particular topic. Let's move on to the next one. Now, recently, the government has came up with a legal provision to address the chemically contaminated sites in India. This particular topic we can associate with the environment section of our prelim syllabus. So previously there was no regulation to deal with chemically contaminated sites including landfills, dumps, waste storage, spill sites, chemical waste handling and storage site. But recently the Environment Ministry has notified new rules under the Environment Protection Act, which has led out a process to effectively address the sites which are chemically contaminated. So under this particular rules, the district administration would be preparing a half-yearly report wherein it would be finding these chemically contaminated sites. Then the state board or the reference organization would be consisting of the experts. Okay, so these experts would be figuring out a remediation plan that how we can recover this particular site. And once the expert body has given the remediation plan, within 90 days, the state board has to come up with a detailed survey and finalize if the sites were indeed contaminated or not. And they also have to identify the persons who are responsible for contamination of that particular site. If they are able to find out that particular person who was responsible for contaminating that particular site, then the cost of remediation of that particular site would be borne by that particular individual or that particular enterprise. But if the state board is unable to find such culprit, then the cost of remediation needs to be beared by the center as well as the state government. And if any criminal liability is proved that, let's suppose this person contaminated a particular site and because of this contamination of this particular site, this impacted right to life of another person, then in that case, if criminal liability is proved, then that person would be subjected to punishment which would be provided under the provisions of the Bharatiya Nyaya Sanhita. Now in this respect, let's note down certain prelim pointers with regard to the Central Pollution Control Board. So it is a statutory body which was constituted in 1974 under Water Prevention and Control of Pollution Act of 1974. And it has also been given the powers and the function under the Air Prevention and Control of Pollution Act of 1981. It provides technical services to Ministry of Environment and Forest under the provisions of Environment Protection Act of 1986 as well. What are the principal functions of this particular body? Basically to promote cleanliness of streams, wells in different areas, basically preventing water pollution and preventing air pollution. What all steps it need to take? It coordinate the affairs of State Pollution Control Board and assist them, provide them guidance and help in conflict resolution also. wherever there is disagreement between different state pollution control boards. It also develops standards for national ambient air quality, water quality criteria for different sources, standards for emission of discharge of environmental pollutants from various industries, which is issued under Environment Protection Rule of 1986, and the standards for treatment and disposal of biomedical waste as well. Now, UPSC has asked a question on this particular body. Do let me know the answer to this particular question. With this, let's move on to the next topic. Now, the last topic of today's analyst is dealing with the concept of living wage. We'll try and understand that how living wage concept is different from that of minimum wages. This particular topic you can associate with the economy section. So, recently a report has been released by Quiz Corporation and Uditi Foundation, wherein they have pointed out that 54% of the blue as well as grey collar women, okay, they are unhappy with the pay that they are getting, and 80% of them are able to save nothing or less than 2,000 per month. So according to this particular report, low wage is the primary reason why women are not entering into blue collar job as well as grey collar jobs. Let's just understand what is the difference between the two kinds of job. Blue collar job usually is characterized by manual work, whereas grey collar job, herein we witness combination of physical as well as intellectual labor. Blue collar job you usually witness in the industrial or construction setting. Grey collar jobs we can witness in the healthcare institution, like for example nurses, we have firefighters, technicians, etc. When you talk about blue collar jobs, the examples are construction workers and factory workers, which basically work on a daily wage basis. Now, this report points out that there is a clear gap between the living wage and the minimum wage. Now, the article points out that what all different barriers women are facing when it comes to this blue collar jobs as well as grey collar jobs. So, the report found out that when it comes to the blue and grey collar jobs, women which are employed in this particular types of job earn 70% of what men do. So, there is a gender pay gap as well. Now, why this low wage is a concern? Because women also have to bear the burden of unpaid care work. They have to take care of the children, they have to take care of the elderly population, plus the commuting cost, plus the migration cost, etc. They are not getting the adequate family support also because they have to come and work in the cities. So this further adds up to the cost. And then when they'll be getting low wages, why would they be incentivized to enter into blue collar or grey collar jobs? Okay, that is what the report is highlighting, that in tier 1 cities, 1 in 5 women earn below 20,000 rupees, and 20,000 rupees is basically a stipulated minimum wage. And the report points out that if we provide the women in these particular jobs higher than this minimum wage, then there is 21% less chance that they will be dropping out of the labor force. Other set of challenges which are witnessed by the women when it comes to these jobs is there is poor work culture, limited access to safe and affordable housing, mobility constraints are there because of violence against women. Then regulatory barriers are there because the laws are different in different states. 54 laws are regulating the factories and the enterprises. There are laws against the night shift, which further prevents or which creates a barrier for the women participation in the labor force. And the write-up is talking about that currently the labor force participation when it comes to females is just 32%. When you compare it with that of men, it is 77%. And if we want to attain the idea of Viksit Bharat, we need to make sure that female labor force participation is increased to 50%. For that, we need to provide women with the living wage. So what is living wage, which the Ministry of Labour and Employment is also considering and discussing this concept? So living wage, herein we also take into account the expenditure done on health, education. Okay, we take into account the expenditure done on health, education, along with taking into account the expenditure done on nutrition, housing and clothing. These three things are considered while we calculate the minimum wage. How living wage would be higher than minimum wage? Because apart from the money that we need to spend on nutritional needs, housing, clothing, we would also be considering the expenditure done by an individual on health and education. Okay, that is the difference between the minimum wage and the living wage. But when it comes to realizing this particular idea, we need a social dialogue with the employees as well as employees, and the ministry is figuring out that how we can put in place this idea of living wage in diverse setting, because I told you regulatory landscape is different in different states. So that also needs to be looked into. That's all that we need to discuss in today's Analyst. Quiz would be coming right up next, so don't forget to practice the quiz and check your knowledge. Till then, keep smiling, keep learning. Have a very great day, all of you.